A new Wordle puzzle is online. Click on the link to play.
Listening to the following video may give you clues. Please like and share the videos.
Access to contraception could be under threat after Roe v. Wade vote. After Roe v. Wade's historic decision, the right to an abortion could come under threat again.
Proponents of Roe v. Wade argue that if Roe is repealed, the number of legal abortions would decrease by 14%.
However, if Roe is overturned, the right to contraception could be severely restricted. This article highlights 3 ways that access to contraception could be threatened.
Anti-abortion group urges state legislators to enact restrictions on abortion. Proponents of abortion rights are asking state legislators to remove barriers to the procedure and expand Medicaid coverage to include the procedure.
The group is also urging states to protect providers from lawsuits and invest in facilities and training to ensure safe and legal abortions. It also wants states to make sure they have enough capacity to provide abortions for abortion refugees.
The proposals come at a time when a growing number of women are seeking abortions if current federal law bans elective abortions in some circumstances.
The state legislatures have been hostile to abortion care, but there have been some recent victories for anti-abortion advocates. Texas has passed a bill that bans elective abortions, but other states have passed a similar law.
Despite the recent victories for anti-abortion groups, state legislators have been blocked by the courts. But the recent appointment of 3 conservative justices to the Supreme Court has given advocates hope for a change in the rulings.
The Chief Justice's opinion in a recent case has hinted that state legislators may have more latitude to enact laws restricting abortion. Another recent victory for pro-life activists in the South Carolina legislature was the governor's signature of a law limiting the procedure.
The heartbeat law requires doctors to check for cardiac activity and will only allow abortions if the pregnancy poses a life-threatening condition or is a victim of rape or incest. However, abortion rights groups immediately sued to block the heartbeat law.
The South Carolina Attorney General, however, has determined that the heartbeat law is constitutional. While the Supreme Court has ruled that abortion is an essential health care choice, state legislatures are taking different paths.
This year, 35 states enacted restrictions on abortion. Half bans or most will not be overturned by the courts unless they are backed by the governors. In addition to the restrictions on abortion, these laws will limit access to abortion for vulnerable populations.
Number of legal abortions will fall by 14% without Roe v. Wade. The Guttmacher Institute estimates that the number of legal abortions will fall by 14% if Roe v. Wade is repealed.
According to the Institute's latest report, the number of abortions has been steadily declining for decades. In 1980, the abortion rate peaked at 29.3 per 1,000 live births.
This year, it is at its lowest level since 1973. A recent study by the Center for Reproductive Rights found that in 21 states, abortion rights are protected by statutes and judicial interpretations of state constitutions.
However, in 25 states, the CRR lists those as hostile to abortion rights. The list includes Michigan, Wisconsin, and Pennsylvania.
But despite the dire predictions of the CRR, women in these states are likely to continue seeking abortions, either through pills or surgical procedures. States that ban abortion are already among the least supportive of women and their babies.
In addition, their rates of child poverty are high. Because of these factors, Democrats are looking at ways to support mothers and babies by expanding Medicaid and creating federal child care.
However, a lack of access to abortion care could exacerbate the problem, making it more difficult for women to access these services. However, they must also consider the health risks of depriving women of their right to choose their own lives.
The draft opinion also says that the Supreme Court has not come close to upholding a ban on abortion. It has argued that Roe v.
Wade has been a major success for the right to have an abortion. This decision was controversial for several reasons.
First, the court has created 3 new justices with records that are hostile to reproductive health. The other 3 justices have ruled against abortion access.
A number of polls have found that if Roe v. Wade is repealed, the number of legal abortions would decrease by 14%.
The Supreme Court's decision, however, has allowed states to criminalize the safe abortion procedure during the second trimester. As a result, Congress must act to prevent further restrictions on access to abortion.
Further, the Hyde Amendment should be permanently repealed and no more legislation should be enacted that would limit federal funds for abortion. State laws banning contraception if they act as abortifacients.
Some states have enacted laws prohibiting the use of contraceptives that act as abortifacients. While abortion is legal, some state laws are intended to protect a woman's health and safety.
For example, a Nebraska state law has a ban on abortions after 20 weeks of pregnancy. Legislators have justified this prohibition by claiming that fetuses are capable of feeling pain even at this stage of the pregnancy.
However, medical literature rejects this belief. After the Roe v. Wade decision, some states have passed laws banning certain forms of contraception if they act as an abortion-inducing agent.
Currently, about 17% to 53% of Americans live in contraceptive deserts. Because contraception cannot substitute for abortion, some states are trying to prohibit access to it.
Many pro-life organizations have been fighting against state laws banning contraception if it acts as an abortifacient. However, if you look at the history of the issue, it's not as simple as banning abortion.
After all, the right to choose your own destiny is an individual right. However, birth control is one of the few legal forms of contraception that most people can use to avoid having an unwanted child.
States are also passing such laws as a response to the possibility that the Supreme Court will overturn Roe v. Wade.
This could mean that abortion is illegal in the U.S., but advocates say this doesn't have to be the case. For now, state laws banning contraception are just the first step.
The Supreme Court's decision has not yet been made, but they'll soon. While these are just two of many cases on the Supreme Court, they are all significant in the context of the right-wing war against contraception.
Some state governments will take these cases as an opportunity to ban certain forms of birth control. If this trend continues, the right wing will be able to ban these methods of contraception.
Fortunately, the court is not bound to overturn Roe v. Wade because it's the law.
Supreme Court justices have ruled against reproductive rights in the past, while the majority of U.S.
citizens support abortion rights. A number of conservative justices have expressed concerns about recent decisions. For example, conservative Justice Samuel Alito said that a decision should be overruled only if an egregious mistake was made.
Solicitor General Elizabeth Prelogar, who represents the Biden administration, said that overturning Roe would be unprecedented for individual rights. In the past, the Supreme Court has ruled against the right to abortion, with the most notable decision being the Stenberg v.
Carhart decision in 2003. The ruling gave abortion opponents a huge victory and prompted many states to consider tougher abortion restrictions.
The court also ruled that a federal ban on abortion is constitutional, but that it lacked an explicit exception for the health of a woman. Because of this, the decision undermined the core tenet of Roe: the health of a woman must come first.
While many states still have laws against abortion, they are not as restrictive as they once were. Some states have even outlawed the practice.
One such law is Bigelow v. Virginia.
In this case, the owners of Hobby Lobby argued that they could not provide birth control coverage to their employees because of religious beliefs. Ultimately, the court ruled 5-4 in favor of Hobby Lobby, which is an example of a closely held corporation.
Roe and Doe set the precedent for the modern legal system. The Roe decision, written in 1973, determined that states cannot ban abortion before the fetus is viable outside the womb.
Medical professionals have long considered viability to be 24 to 28 weeks. However, Mississippi's 15-week ban was a violation of Roe.
Justice Blackmun wrote the majority opinion in Doe. The current conservative majority is a threat to the rights of women and children.
Women and people will suffer because of this conservative majority. Reproductive freedom and equality are fundamental human rights that are being undermined by the current conservative majority.
There are several ways to combat the conservative majority. One of the most important ways to fight back is to elect a liberal Supreme Court justice who supports reproductive rights.